From an authoritarian abroad to an authoritarian here at home. A federal judge has cited Donald Trump's, quote, own words and actions as evidence to suggest that he was in a conspiracy with extremists to overturn the 2020 election. District Judge Mehta rejected Trump's request to toss out lawsuits by members of Congress and police officers seeking damages for physical and emotional injuries incurred on January 6th.
From an authoritarian abroad to an authoritarian here at home, Donald Trump, the man who spent years convincing half of America that rules simply did not apply to him, just got handed the most expensive reality check of his political career.
In a scathing 112-page opinion, the judge said that Trump's words show that he and the Proud Boys and Oath Keepers, quote, pursued the same goal, and that Trump would have known his words were understood as a, quote, call to action, and that his response to the violence made it all the more plausible that he was involved in a, quote, tacit agreement with the rioters. Joining us now, former U.S. Attorney and MSNBC contributor Barbara McQuaid and Charlie Sykes, who is still here. Barb, this opinion is a barn burner. I could quote from it, but maybe I will. But first, I just want to ask you what you make of it and why it's important.
April Fool's Day 2026, and the joke landed exactly where it belonged. The self-appointed strongman who treated presidential immunity like a personal insurance policy just watched a federal judge cancel that policy mid-claim. In a punishing 112-page ruling, Judge Mehta didn't bother with subtlety. He picked apart Trump's immunity arguments with the kind of precision usually reserved for surgeons and tax auditors, two categories of professionals Trump has historically tried very hard to avoid.
Well, legally, John, the reason it's important is it says that these lawsuits can go forward. You know, ordinarily a president is able to use immunity to get out from under civil lawsuits. Anything he does within the scope of his presidency is up for immunity. But what the court said here is he wasn't acting as president. He was acting as a disgruntled candidate.
This evidence that the former president of the United States engaged in seditious activity, that he abused his office, that he was part of this effort to block the peaceful transfer of power. This is an amazing moment. And I think that the positive thing that we need to focus on is the fact that there are still avenues to hold him accountable. I think the great tragedy would be if Donald Trump was not held accountable for his conduct in all of this. So, you know, whether it's going to be the Department of Justice or whether it's going to be the January 6th Commission or whether it's going to be these civil lawsuits, you have to hope that something comes of that, there are consequences to this, and that people are paying attention to what this man did and tried to do to this country at a moment of great peril.
The conclusion was straightforward and brutal. Trump's January 6th speech at the Ellipse was not a presidential act. It was a campaign tantrum delivered by a candidate who lost and simply refused to process that information. No official White House coordination, no government resources, no formal executive function, just a man with a microphone and a grievance, pointing an angry crowd toward the Capitol and calling it patriotism. On the Georgia phone call, Judge Mehta was equally unsparing. He described it plainly as the words of an office seeker begging a state official to manufacture votes, not a president executing his constitutional duties.
I just want to find 11,780 votes, which is one more than we have, because we won the state.
For a man who has spent years insisting he did nothing wrong, having a federal judge spend 112 pages explaining exactly how wrong he was must sting in a very particular way. The Supreme Court gave Trump criminal immunity for official acts. Civil court, however, is not interested in that arrangement. On January 6th, Trump wasn't governing. He was losing, loudly, publicly, and with considerable enthusiasm, and the courts are now treating him accordingly. These civil lawsuits are moving forward, and the machinery that comes with them is precisely what keeps Trump's legal team awake at irregular hours. Enter civil discovery, the part of the process where I don't recall stops being a viable personality trait. With immunity stripped away, plaintiff attorneys now hold subpoena power over emails, text messages, call records, internal White House memos, and every communication that touched the days surrounding January 6th. Every warning Trump received and ignored, every conversation threading through the fake elector scheme, every contingency plan drafted by people who understood they were losing and refused to accept it, all of it is now fair game. Then come the depositions, and here is where civil court distinguishes itself from the criminal proceedings Trump has spent years navigating with remarkable agility. In criminal court, the Fifth Amendment is a reliable friend. In civil court, that friend does not show up. If Trump refuses to answer, jurors are legally entitled to draw negative inferences from that silence. They can simply decide he is hiding something because the alternative explanation, that he just genuinely cannot remember anything relevant, tends not to play well either. This is the legal exposure Trump could not buy, pardon, or politically outmaneuver his way out of. He survived criminal prosecution through a combination of electoral timing and favorable immunity rulings. Neither of those tools functions in civil court. No loyalist attorney general can quietly shelve these cases. No pardon exists for civil liability. For the first time since January 6th, Trump may be required to sit across a table from opposing counsel and answer under oath with specificity what he knew, when he knew it, and what exactly he intended when he directed that crowd toward the building where his own vice president was certifying his defeat. The strongman who built a brand on being untouchable is about to discover that civil court has never heard of that brand. And behind the legal procedures, there are people. Discovery is not just paperwork. It is the mechanism by which Capitol officers finally get to tell their stories in a formal proceeding, on the record, with Trump required to be present. Officer James Blasingame left January 6th with a concussion, broken bones, and PTSD that restructured his daily existence. Injuries sustained in direct physical combat while defending a building that contains, among other things, the office of the man who sent the crowd there. Officer Sidney Hemby absorbed chemical burns from bear spray and hand injuries that continue to affect him years later. And then there is the family of Officer Brian Sicknick, whose longtime partner filed a wrongful death suit after Brian died in the days following the attack, having been assaulted by rioters just hours before his body gave out entirely. These are not abstractions. These are not talking points or political footnotes. These are Americans whose lives were permanently altered because a candidate decided his personal ambitions outweighed the consequences to everyone around him. NACP President Derek Johnson and lead counsel Joe Sellers framed the legal history plainly. For the first time in this nation's existence, a court has ruled, on the evidentiary record, that a president may be held personally liable for harm caused while in office. That is not rhetoric constructed for a campaign rally. That is a legal precedent being established in federal court, one ruling at a time. Now to the dimension of this story that tends to focus Trump's attention most effectively, the financial dimension. Civil court does not traffic in political theater. It issues judgments, and the record suggests Trump's relationship with civil judgments is both extensive and expensive. E. Jean Carroll pursued him through 2 separate lawsuits for sexual assault and defamation. 2 juries. 2 verdicts. Total damages, $83.3 million upheld on appeal. Trump left the courtroom before closing arguments finished and was absent when the verdict arrived, which is one way to handle a situation, though not typically the recommended one. He called it a sham, appealed, and lost. The image of an American president ordered by a jury to pay tens of millions to a woman he spent years publicly attacking does not photograph particularly well for someone whose entire identity rests on never losing. The broader record continues in a similar direction. Trump University, shut down following systematic fraud against students, settled for $25 million. The Trump Foundation, dissolved by court order, $2 million in restitution for misusing charitable funds. The New York business fraud case, $354 million judgment. Every one of those civil proceedings, every one of those resolved without the Fifth Amendment available as a shield. Every one of those concluded with a check bearing Trump's name in the payee line. Now place that same legal framework in a courtroom where the witnesses are Capitol officers describing, in specific and documented detail, what January 6th did to their bodies. Juries are composed of ordinary people. Ordinary people tend to respond to testimony about concussions, chemical burns, and permanent disabilities inflicted on law enforcement officers. Legal analysts suggest potential damages in these cases could exceed the Carroll Awards by a considerable margin, which, given that the Carroll Awards themselves were not a modest sum, represents a number worth contemplating. Trump's legal team is predictably characterizing this as an outrage. The standard statement arrived within hours of the ruling. The former president was simply acting on behalf of the American people, a framing that Judge Mehta had already spent 112 pages systematically dismantling. The appeal is coming. The procedural delays are coming. The clock-running strategy is as reliable as anything in Trump's legal repertoire. But one detail is telling. His team allowed the window for an emergency appeal directly to the Supreme Court to close without filing. That is not an oversight. That is a calculation, and the calculation suggests they already know the Supreme Court is unlikely to extend its prior immunity framework to cover civil liability for conduct that reads, in Judge Mehta's own assessment, like the actions of a political candidate rather than a sitting president. The cases move forward. Discovery begins. Depositions get scheduled. Members of Trump's inner circle may find themselves answering detailed questions under oath about the planning, the communications, and the decision-making that characterized the weeks surrounding January 6th. For a man who has invested substantial energy into keeping those communications buried, this is a level of exposure that has no modern precedent. Unlike the criminal cases, which dissolved after his electoral return and the immunity decisions, these civil suits operate in a jurisdiction where presidential power is irrelevant. Trump cannot pardon a civil judgment. He cannot reassign the opposing lawyers. The one legal battlefield where his usual toolkit does not apply is now active, scheduled, and advancing on a timeline that his team cannot dictate. Beyond the courtroom, this ruling does something quieter and potentially more lasting. It chips directly at the structural foundation of Trump's political identity. The brand was always built on invincibility. He told his supporters consistently and without qualification that he was the fighter they could never bring down, that indictments made him stronger, that convictions only deepened the loyalty of those who believed in him, that the system could throw everything at him and he would convert it all into momentum. And for a while that narrative held. The criminal cases faded. The immunity decisions landed favorably. The electoral return looked from a certain angle like confirmation of everything he had claimed about himself. Civil court does not photograph that way. It is slow, public, and personal in a manner that political theater cannot reframe indefinitely. Picture the visual. Capitol officers on a witness stand describing under oath and in granular detail how they were beaten with poles, sprayed with chemicals, and left with injuries that years have not resolved, while the man they hold responsible sits in the same room, legally required to listen. That image does not reinforce the strongman legend. It tells a different story about what that legend actually cost the people standing between him and the outcome he wanted. In the Carroll case, Trump's own courtroom behavior, the early departure, the public dismissal of the verdict, the continued attacks on the plaintiff, made him look smaller, not larger. A jury of his fellow citizens found him liable regardless. The same dynamic is now available to repeat itself on a considerably larger stage with considerably more sympathetic witnesses. 5 years after January 6th, the criminal exposure has largely dissipated. The civil accountability has not. No pardon mechanism exists for it. No appointment can neutralize it. Judge Mehta's ruling has opened a legal door that functions independently of executive power, and Trump, for all his demonstrated ability to navigate, delay, and outlast legal challenges, has not yet found a method for closing it. This is not the conclusion his supporters anticipated. While Trump projects total dominance and declares victory across every available platform, injured officers and their families are quietly building cases through legitimate legal channels, one filing at a time. The so-called untouchable strongman is learning, at a pace set by the federal court calendar rather than his own preference, that certain consequences do not respond to rallies, social media posts, or the sheer force of insisting loudly that they do not exist. Civil justice moves on its own schedule, and right now that schedule has Trump's name on it. I'm your host at Trump Mana Empire. Verify everything you hear. Sources and court documents are linked below. Will these civil proceedings deliver the accountability that criminal courts could not? Or does Trump find another mechanism to run the clock? Drop your take in the comments. If this is the kind of direct analysis you're looking for, hit like, subscribe, and turn on notifications. We stay on this until it resolves. No spin, no filler. See you in the next one.